can be a member of a registered union and can enjoy all rights and privileges to such members. So these are the legal provisions or provisions regarding the minors agreement. The next one we will discuss persons of unsound mind. The second category of incapable person we can say unsound people. Section 12 of the Contract Act 1872 defines the term soundness of mind. According to section 12, a person is said to be sound to be of sound mind for the purpose of making a contract if at the time when he makes it, he is capable of understanding it and forming a rational judgment as to its effect upon his interest. See, this is the section 12. According to section 12, a person is said to be of sound mind for the purpose of making a contract if at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to its effect upon his interest. So if we discuss this definition, we can say there are two elements which are essential for soundness of mind. First one is capacity to understand, and second one is capacity to make a rational judgment. See, these are the two. If you go through this definition, section 12, according to section 12, a person is said to be of sound mind for the purpose of making a contract if at the time when he makes it, he is capable of understanding it and forming a rational judgment as to its effect upon his interest. So if we discuss this definition, we can see two essential elements are there. First one is capacity to understand, and second one is capacity to make a rational judgment. Then next one, a person of sound mind may be divided into two broad categories. First one is idiots. An idiot is one who has lost his mental capacity permanently. So an idiot is one who has lost mental capacity completely, that is, his brain has not developed enough to enable him to understand the contract or of forming a rational judgment of its effect upon his interest. So that is why a contract, an idiot is a person his mental capacity is completely lost and he is not able to make a contract. Then next one, that is why an agreement with an idiot is it is void ab initio. The next category we can say lunatic. Lunatic means a drunkard lunatic means a person, his mental capacity is completely deranged due to certain disease or some causes. Maybe his mental capacity is completely deranged. So lunacy arises from the illness of the brain or mental or body's distress. So this is actually not a complete incapacity. Sometimes maybe a lunatic person, sometimes they are capable to enter into contract. Whenever he is in normal situation, he is capable to enter into a valid contract. Whenever he is at the stage of lunacy, that time he is not capable to make a valid contract. So essential element of lunacy is that the mental power of the lunatic are so deranged that he cannot make a rational judgment of any subject the period of lunacy. So this is sometimes this is a temporary incapacity, sometimes it is a permanent incapacity itself. And the next one, other disqualifications. These are the some categories of people are disqualified from entering into a contract. First one is an alien enemy. See, at the time of war, we used to declare the other country as alien enemy. So during this war time, any kind of transaction between an importer in India or an exporter in India and an importer exporter outside the alien see alien country, see that such kind of contracts are void and they are not able to make a valid contract. The next one is foreign sovereigns and their ambassadors. Foreign sovereigns and ambassadors in India can enter into contract with Indian citizens and can sue them in Indian court, but no suit can be filed against them in local courts unless the permission of the central government to this effect has been obtained. So for foreign sovereigns and ambassadors having certain limitations to enter into a contract and file a case against the Indian citizens or Indian citizens to these foreign sovereigns and ambassadors, because it requires the permission from the central government and all. The next one is corporation. So a corporation is an artificial corporation, means a joint stock company or any registered body corporate. See, they are treated as an artificial person. See, being a legal person only, it cannot file, it cannot act by itself. So they cannot file. They are temporarily, some kind of incapacity is there. Only the natural person, the directors, they can act. They can file a case against, or they can make a valid contract. The next one is insolvent or bankrupt. The person who are adjudged as insolvent or bankrupt. See, when a person adjudged as insolvent, he loses his contractual powers to make a contract. And next one is convict, as a person against whom a sentence of imprisonment is passed. See, in that case, his capacity to enter into contract will lose. See, these are the disqualifications applicable to some categories of parties like alien enemies, foreign sovereigns and their ambassadors. Then we can say corporations, insolvents and convicts. The next topic, another important topic, we can say free consent. This is another essential characteristic of a valid contract. Suppose there is no free consent, that contract will be treated as voidable. It is voidable at the option of the party whose consent is not free. The term consent, suppose we are talking about free consent. The term free consent consists of two requirements. First one is there should be a consent, and that consent should be free. There should be a consent and that consent should be free. Section 13 of the Indian Contract Act 1872 defines what is consent. According to Section 13, two or more persons are said to consent when they agree upon the same thing in the same sense and at the same time. See, this is the definition of Section 13 regarding consent. According to Section 13, two or more persons are said to consent when they agree upon the same thing in the same sense. See, Section 14 defines free consent. So according to Section 15, consent is said to be free when it is not caused by coercion as defined in Section 15, or undue influence as defined in Section 16, or fraud as defined in Section 17, or misrepresentation as defined in Section 18, or mistake subject to the provisions of Section 20, 21 and 23. See, this is the definition of free consent. So according to Section 14, consent is said to be free when it is not caused by coercion as defined in Section 15, or second one, undue influence as defined in Section 16. The third one is fraud as defined in Section 17, or the fourth one, misrepresentation as defined in Section 18, and fifth one is mistake subject to the provisions of Section 20, 21 and 22. See, the next one we will discuss one by one. What is coercion, what is undue influence, what is misrepresentation, what is mistake, etc. So first of all, we will start with the definition called as coercion. So Section 15 defines what is coercion. According to Section 15, coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with an intention to causing any other person to enter into an agreement. See, this is the definition of section 15. According to section 15, coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code or the prejudice of any person to enter into a valid contract. So coercion means threatening or committing or threatening to commit any act which are forbidden by the Indian Penal Code, or the unlawful detaining or threatening to detain something with an intention to enter into a contract with the other person. The next one, what will be the effect? Suppose we are exercising coercion, what will be the effect of the contract? So according to section 19, whenever there is the consent is not free, or whenever the consent of a person is by coercion, such type of contract will be treated as a voidable contract. It is voidable. It is voidable in the sense that it is voidable at the option of the party whose consent is not free. So in that case, the party whose consent is not free, he is in a position to treat that contract is void and similarly valid also. Suppose he is having no objection, so in that case such type of contract will be valid. Suppose he is having objection regarding this contract, so he is in a position to file a case against the other person, showing that whenever he is making the contract, the consideration was the consent was not free. And there is one case study called as Ranganayagama versus Alvar Sethi. See, this is regarding coercion. A young girl of 13 years was forced to adopt a boy to her husband who had just died by the relatives of the husband, who prevented the removal of his body for the cremation until she consented. So held, in this case, that lady, maybe she gave some consent regarding the adoption, but this consent is not free. So in that case, such kind of agreement is void, and that adoption will be treated as void. Consequently, the adoption was set aside. This is an example. This is a case study regarding the coercion. The next one, there is one more case study. Suppose we are asking about a question: is threatening to commit suicide amounts to coercion or not? So threatening to commit suicide is amounts to coercion, because this is an act they are forbidden by law. So any kind of threatening to commit suicide in order to enter into a contract, that threatening to commit suicide will amounts to a coercion. So there is one case, in order to substantiate this point, there is one case study called as Amiraj versus Sheshama. See, in this case, what happened? A person held out of a threat to commit suicide to his wife. The wife executed a deed in favor of his husband's brother regarding the transferring of some property. See, this is mainly because of that executing that deed is mainly because of threatening to commit suicide. That is why this lady executed a deed in favor of transfer of property in favor of husband's wife. See, later on, that lady filed a case against the other person, showing that agreement, that contract is mainly because of that transfer of property is mainly because of threatening to commit suicide, and that amounts to coercion. So that agreement, that transfer of property is not valid. So we can say even threatening to commit suicide is also treated as a coercion. The next one, see, these are the discussions about coercion. The next one we will enter into another topic called as undue influence. See, this is section 16 subsection 1 defines what is undue influence. According to section 16 subsection 1, a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the party is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. See, this is in case of undue influence, there should be a peculiar relationship subsisting between the parties. According to section 16 subsection 1, a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the party is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. See, in this case, in order to exercise an undue influence, there should be a peculiar relationship subsisting between the parties. For example, suppose we are talking about the relationship between doctor and patient. Suppose you are talking about the relationship between a lawyer and his client. See, even a teacher and student. See, in this case, a spiritual guru and devotee. See, in this case, we can say some sort of peculiar relationship is existing, and see, as far as a doctor is concerned, he is having the position to dominate the will of the other. He is prescribing medicine, and the patients, they used to have it. And similarly, a spiritual guru is having a position to influence the acts of the devotees also. Suppose this spiritual guru or doctor or lawyer or a teacher who is having a power to dominating the will of the others. Suppose they are exploiting this relationship and exercising some kind of agreements in order to get some benefit. Such situations we can say the undue influence is there, and there are three conditions should be fulfilled in order to exercise undue influence. The first one is the relationship between the contracting parties should be such that one party is in a position to dominate the will of other. The second one is such a party has used that dominant position to enter into a contract with the latter, and the third one is such a party has obtained an unfair advantage over the other. See, these are in order to we can say that in order to exercise undue influence, the three essential elements should be there. The first one is that the two parties, the relationship between the two parties are such that one is in a position to dominate the will of the other. The second one is such a party used that dominant position to enter into a contract with the latter, and he is getting some unfair advantage over the other. See, suppose these three conditions are fulfilled, we can say undue influence is there. And there is one case study regarding undue influence called as Alcard versus Skinner. See, in this case, Alcard decides to join a convent, and her property donated to Skinner, the mother superior of the convent. And after a few months, after 6 months, she left the convent, and after 6 years later, after leaving that convent, after 6 years, Alcard claimed that whatever property she contributed to the mother superior, she is claiming back. But see, in this case, the court held that whatever property or money contributed to this mother superior, that convent, it is not recoverable, mainly because of the lapse of time. Because as per the Limitations Act, Indian Limitations Act, see, such kind of transactions, it should be claimed back, or it should be transacted within a reasonable period of time, usually 3 years, or it might be 5 years. So in this case, that Alcard, she is claiming back that property only after 6 years and after lapse of time only. So in that case, that property is not recoverable. At the same time, suppose she is claiming back within a reasonable period of time, within a period of 3 years, definitely that property should be returned, because some sort of undue influence is existing between the Alcard and Skinner. And there is another similar case regarding this undue influence called as Manu Singh versus Umadat Pandey. See, in this case what happened, a spiritual guru induced his devotee to gift him the whole of his property in return of a promise of salvation to the devotee. In this case, the spiritual guru induced his devotee to contribute his entire property to this spiritual guru, saying that suppose you are contributing this your property to the spiritual guru, he will get salvation. So this is actually made out of, this agreement is made out of undue influence, and the consent of the devotee was due to undue influence only. So in this case, that property should be, there is no, see, there is contract is there, that contract is voidable contract only, and the devotee is in a position at any point of time, within a reasonable period of time, he is in a position to claim back this particular, whatever property contributed to the spiritual guru, because there is a clear evidence of undue influence. And the next one, see, these are the discussions about undue influence. And one more point, what will be the effect in case of undue influence? See, the effect of the effect of undue influence will be the similar to the coercion. Whenever there is free consent is missing, in that case such type of agreements will be treated as voidable agreements or voidable contract. So in this case also, the agreement, the consent, the party whose consent is not free, he is in a position to treat it as valid contract, and see, void contract also. That means this is a voidable contract. It is voidable at the option of the party whose consent is induced by undue influence. Okay, so the next one is what are the differences between coercion and undue influence? The first point of difference, we can say type of pressure. The type of pressure, see, in case of coercion, physical or crude force is there, but in case of undue influence, we can say only mental pressure is exercising. And the second point of difference is burden of proof. See, in case of coercion, prove how the coercion was exercised, and in case of undue influence, prove the other party has a dominating position or a peculiar relationship subsisting between the parties. And third one is natural transaction. The party who uses that position to obtain unfair advantage over the other. The transaction, though fair but induced by coercion, can still be avoided. See, these are the differences between coercion and undue influence. The next point for discussion, we can say fraud. This is also related to free consent, lack of free consent. So what is fraud?